Okay. Good morning, everyone. First, I would like to thank the University of Valencia and the organizing committee of the summer school for having me today and for the opportunity to be part of this series of lectures. As said by Professor, who I thank for the kind words of introduction, my research activities mostly focus on legal implications of the development of artificial intelligence. Today, I wish to discuss with you some issues related to civil liability in cases of damages caused by the circulation of self-driving vehicles. Um, First, okay, you are certainly aware of the many challenges and the criticalities that arise from the development of artificial intelligence and the robotics at a systematic level, requesting both the European and the national lawmakers to update the existing legal frameworks. Specifically, the development of artificial intelligence is calling legal scholars to discuss new and uncharted issues related to civil liability for damages caused by autonomous robots. In its 2020 report on the safety and liability implications of artificial intelligence, the European Commission enumerated the following characteristics that distinguish new technologies which apply AI tools from traditional technology. And we can see in this first slide, complexity, openness, autonomy, and opacity. Let us see these characteristics in further details. First, new technologies are complex, meaning that products and services are more interconnected than before. And, uh, and these applications of AI are even so often integrated into complex environment, such as the Internet of Things. Several players are involved into the functioning of these newest technologies, such as producers of goods as well as producers of services and users. Second, new technologies are open. In fact, being structurally incomplete, they have to be open by design. They need constant revisions, updates, or upgrades, and they have to interact with other products or services in order to function properly and develop their full potential. These characteristics make new technologies potentially vulnerable to cyber attacks, which may aim to cause malfunctions or to modify the outputs in order to cause damages. Third, new technologies are able to act autonomously, and when employing self-learning algorithm, they are also able to modify their original algorithm and to develop their own behavioral patterns on the basis of which they will interact with the surrounding environment. This characteristic appears to me to be the most relevant. It is this feature that requires a revision of the legislative framework currently regulating the liability of the producer. New technologies are moreover opaque, meaning that the more complex they are, the less we will be able to fully understand their functioning. It is the so-called black box effect. It may be increasingly difficult to ascertain the origin of a certain damage and to identify the subject that should be held accountable for it. If we take into account a self-driving vehicle, for example, which is interacting with other self-driving vehicles on connected road structure and while connected to other cloud services, in case of a car accident, it may be highly complex, if not impossible, to understand at which level of the chain the malfunctioning occurred and what caused it. The opportunity to obtain a full compensation for damages suffered may be concretely precluded, for instance, by the high cost of acquiring an expert witness that shows that the product is defective and that explains why and how the algorithm did not correctly perform its task. Also, the access to the information related to the malfunctioning of the algorithm would be exclusively obtainable with the cooperation of the subject, but potentially cause the damage. Therefore, we should ask which solution, which solutions have been proposed to ensure the safeguard of citizens' rights in case of damages caused by new technology. As I have already mentioned, among the innovative features of new technologies that use AI tools, the most remarkable is the capability to undertake autonomous decisions based on behavioral patterns that are developed according to the previous interactions with the surrounding environment. These decisions are by definition unforeseeable, meaning that not even the programmer, the author of the algorithm, is able to fully understand and explain why certain inputs generated a specific output. These peculiarities of new technologies undermine the traditional model of civil liability for damages that is mostly applied by the member states of the European Union, which is that of tort liability based on fault. Fault-based liability is based on the assumption that the occurred damages are somehow foreseeable. An individual can be held accountable for the damage if and only if he was able to foresee the damage that occurred. From the fault-based liability model, we distinguish the strict liability model, in which liability derives from, for example, the existence of a mere relationship between the thing and the person which is to be considered liable, or from the performance of dangerous activity. This model of liability operates without fault or misconduct on the part of the subject which is to be held accountable. Among the various types of strict liability, scholars also include product liability. According to the product liability model, liability arises when there is a defect in the fabrication process of a certain product, or in the design of the product, or even in the lack of warnings. This hypothesis of product liability share with the fault-based liability model the requirement of the foreseeability of the damage. In fact, foreseeability is the core of the development risk defense provided by Article 7, letter E of the PLD, the Product Liability Directive, according to which the producer is not to be deemed responsible when the state of the art of the technological and the scientific knowledge did not allow the producer to discover the existence of the defect. The models of fault-based liability and product liability have been developed according to the 18th century scientific method that is according to the idea that the more we know, the more we are able to understand, and ultimately, the more we are able to foretell or foresee. Yet, autonomous robots break this line of thinking, since their way of acting and of interacting with the environment are by definition uncertain. In order to deal with the innovations brought by the development of AI, legal scholars and European institutions are investigating the most suitable regime of civil liability, aiming at granting citizens an effective protection from damages caused by robots, while still incentivizing new investments in the sector of the market. The specific approach that will be adopted by European institutions seems to be centered, on one hand, on the principle of functional equivalence, but aims at avoiding that the application of newest technologies leads to a decrease in safety and liability in comparison to traditional technologies. And on the other hand, on the allocation of the liability for damages caused by new technologies on those subjects who are actually able to minimize them. Prospective solutions are the following. First, to grant the status of a legal person to the machines. This approach is suggested for extremely sophisticated tools which are able to undertake decisions and interact with the outside world. In essence, it is the machine itself to be strictly liable for the damages caused. The machine will also have the duty to compensate those damages using a certain fund. The solution was initially considered by the European Parliament in his 2017 resolution. However, the European Commission abandoned this approach in its 2020 report, since the expert group did not consider it necessary to ensure the protections of citizen rights. Several arguments, in my opinion, make this approach unacceptable. First of all, it will diminish the cautionary function of civil liability, which is an essential ratio of civil liability. Secondly, it will request the expansion of the concept of legal persons, introducing a new type of legal person which has a duty but is not entitled to any right, a sort of a digital slave. The second perspective solution is based on the strict liability of the persons who operate the machines. For example, the user, the owner, or keeper of the device, such as the liability model applied for damages resulting from motor vehicles, specifically when new technologies operate in public environment with risk of serious damages, such as public roads. Some scholars suggested to partially waive the operator's liability in reference to closed device, that is, those devices on which the operator has no control on the risk conditions of the device itself, and it cannot integrate updates that are provided by third parties, and to also apply a higher liability standard on the producer itself. Others suggest to apply the product liability regime outlined by the PLD, the Directive on Product Liability, also to producers of new technology. In essence, a producer will be held accountable for the damages caused by new technologies that they put on the market if those technologies are defective. In order to apply this model, it has been said that some updates to the current legal framework would be necessary. First, the definition of products should be modified in order to include AI systems. Second, a producer should not be entitled to invoke the development risk defense provided by Article 7, letter C of PLD, which is currently optional for member states, and some member states already implemented this defense, and Italy is one of them with Article 118, letter E of the Consumer Code. The necessity to limit the application of the development risk defense has been said by the report from the expert group on liability and new technology, specifically in regard of producers that, following the launch of AI-based product on the market, are still able to exercise control over the AI by using updates and upgrades. This option is not considered in the European Commission's report on the safety and liability implication of artificial intelligence, the Internet of Things, and robotics. Some scholars also propose that producers' liability should be enhanced by imposing a duty to grant insurance coverage on damages caused by products. However, the cost of the insurance would ultimately lead to an increase in the price of the product itself. The European Commission is instead proposing to revise the text of the PLD by modifying the notion of putting into circulation a new technological product, extending until the end of the life cycle of the device. According to the Court of Justice, a product is put into circulation when it is taken out of the manufacturing process operated by the producer and enters a marketing process. The time that the product was put into circulation is critical, since producers are only liable for defects that existed at the time. By implementing this kind of revision, the moment in time to evaluate the existence of a defect will be extended to after the product becomes available on the market. This will limit the possibility for producer to resort to the so-called supervening defect defense upon Article 7, letter B of PLD, according to which the producer cannot be held liable if the defect that caused the damage did not exist at the time when the product was put into circulation. The producer will then have a duty to monitor the function of the product for the whole duration of its life cycle. In case the producer does not detect certain malfunction that causes the product to be unsafe, the producer will be strictly liable for the damages caused by the undetected defect, regardless of fault. The producer will be liable even if it demonstrates to have undertaken the supervision, yet without promptly discovering the anomaly or blocking the device. In my opinion, this solution strikes a balance between the necessity to uphold citizens' rights and the interest of the market to avoid excessive burdens on producers. However, it seems to me to not be exactly coherent with the interconnected and open nature of new technology that we discussed before. When a new technology is implemented with updates and upgrades, which are not provided by the original producer, but by a third party, it may be unfair to allocate the cost of subsequent damages on the original producer. It is also true that the Commission proposed a new safety standard that will encourage producers to design products which are not accessible from external operators. This proposal may be effective to grant products safety, yet it may also be inefficient as it would cause the cost of the final product to rise, as well as the cost of adding one of the product's components. In this first part of my presentation, I tried to introduce you to the general picture. Now it is time to tackle specifically the case of liability for damages caused by the circulation of vehicles. This, using the wording of the 2021 regulation proposal on harmonized rules on artificial intelligence, is an high-risk sector, but is a sector with a frequency of risks of severe damages. So, which is a liability for damages caused by automotive automatic vehicles? One of the sector of the market that will mostly be influenced by the new technology is without any doubt that of automotive. An industry that since the 80s is aiming at designing vehicles that are able to partially or completely drive themselves. From the technical point of view, I will limit myself to the classification of the 5 level of automation implemented by Society of Automotive Engineers International. This classification that we can see in the slide is widely adopted by policymakers and has the purpose to distinguish the types of vehicles according to who is in control, e.g. the driver or the automation system. What is the current civil liability for damages deriving from it? Let us quickly revise that. In case of car accident, on the basis of the national law of the member states, and for what concerns Italy, it is Article 2054 of the Civil Code, the party the party that suffered the damage is entitled to compensation from the owner of the vehicle, who answers according to the strict liability model. The party who suffered the damages is also entitled to compensation from the driver, who is liable for fault. The driver is held responsible unless he gives proof to have done anything possible to avoid the damage. This burden of proof, according to the case law, involves the proof of an event which interrupts the causal link between the driver's conduct and the damage. such as the conduct of the person who suffered the damage, e.g. the passerby who throws himself in the middle of the street, or the unforeseeable event. Also, the producer of the vehicle is liable, according to the PLD, for defects of the product that cause a damage. It is a form of concurrent liability with the owner and driver. However, in case of car accident, producer's liability is largely irrelevant. For instance, accidents are very often caused by driver's errors. And secondly, it is quite hard to demonstrate the existence of a defect for the party who suffered the damage, while it is easier to act against the insurance company. The spread of self-driving vehicles raises new issues in respect to the model of liability I just described. In the experimentation phase, vehicles are not allowed to circulate without a driver who is in charge of taking control of the vehicle if needed. Yet, in the near future, the driver will be less and less able to control the risk from the circulation. There is a general consensus that prospective liability models for self-driving vehicles should maintain owners' strict liability and mandatory insurance, should, on the other hand, overcome the current regime of the driver's strict liability, since the driver is no longer in a position to control risk, even more so with vehicles with higher level of automation. I mentioned that the European Commission is determined to avoid that the prospective large-scale application of the new smart technologies entails a decrease in liability in comparison with the traditional technology. Therefore, if the driver could no longer be held accountable for damages deriving from the circulation of vehicles, how can we grant full protection to citizens? Many proposals have been advanced, and I will summarize some of them, which I consider to be particularly relevant. According to some scholars, it should be enhanced the level of liability of the producer of the self-driving vehicle, according to PLD. The producer would then be subject to a strict liability regime and should not be allowed to invoke the development risk defense that I mentioned before. Other scholars said that the activity of the producer of self-driving vehicles should be considered, at least in the initial phase, as a dangerous activity, and should therefore be subject to the subsequent strict liability regime according to national laws. The European Commission proposed a different solution. As mentioned before, according to the Commission, the producer should have a duty to monitor the device for the whole duration of the life cycle of the device. If during this period the producer does not detect the anomaly but makes the product unsafe, then he will be strictly liable for damages caused by the defect. The producer will nonetheless be entitled to the development risk defense, which should not be barred according to the Commission view. The Commission, instead of increasing the level of liability of the producer, suggests to consider liable also other subjects who may be in the position to implement the control of risk. Specifically, in the driverless car sector, the Commission proposed to apply a strict liability regime on the figure of the operator. To this end, the report from the expert group on liability and new technologies distinguishes between front-end operator and back-end operator. Front-end operator, that is the user of the vehicle. This subject should be responsible as long as it decided when, where, and why the device is used and benefits directly from it. The back-end operator is the provider that handles the controls of the traffic, detects risks, and provides services which aim at supporting the circulation of vehicles. The subject benefits from the activity since he gains a profit from it. By examining the various reports and proposals that have been published, I think it is possible to infer that the European lawmaker does not intend to impose a strong form of strict liability on the producer. That is a liability which is not weighable through development risk defense. It would seem instead that the trend is that of adding to the producer's liability, with the amendment to the model I just mentioned, a new rule of strict liability of operators. including both front-end operator and back-end operator. In market sectors where AI application entails higher risk, such as transportation, the prospective model of civil liability to be adopted seems to be the following. The vehicle's owner and/or the provider will answer for strict liability, since these are the subjects who have the means to implement a more efficient risk management, even by activating insurance policies. Second, the producer of the vehicle will be liable within the limits of the state-of-art defense. The other operators, e.g., owner and/or the provider, will have action against the producer for restitution where the damages are caused by a defect in new technology. The producer will also be burdened with the duty to monitor the functioning of this device for its whole life cycle. And I'm coming to the end of my intervention. Okay. The 2020 EU Commission proposal was further elaborated into the Parliament resolution for a new regulation. The Parliament proposed to distinguish between applicable civil liability regimes on the basis of the degree of risk associated with a certain new technology. In further detail, according to the regulation proposal, there is an high risk when AI tools operate autonomously and can cause damages in an unforeseeable way. In cases of application of high-risk AI systems, Article 4 of the proposal holds that the operator is strictly liable for any damage caused by the activities, by the devices, and by the physical and virtual process guided by the AI systems. Only a cause of force majeure can exclude liability, and there is, and it is provided a duty to have an insurance policy. In case of other, e.g., non-high-risk AI systems, the proposal established that operators are only liable for fault for the damages caused by the activity, by the devices, and by the physical and virtual process guided by the AI systems. The operator is not liable if he proves that the AI systems activated without the operator knowing, and notwithstanding the fact that the operator adopted all the safety measures to avoid the activation, or that the operator acted with due diligence in choosing the AI system, in activating the system, and in monitoring its activities, implementing periodical updates. Also in this case, there is a force majeure cause, and the operator is jointly liable with other operators of the same AI system. It is interesting to notice that in order to overcome the issues linked with opacity of artificial intelligence, the producers of AI system has to cooperate with the operator or with the person who suffered the damage, providing the necessary information to identify the subjects who caused the damage. I think, in my opinion, the proposal advanced by European institutions should be praised for their attempt to grant protection of citizens' rights, while at the same time trying not to discourage new investments in the technological sector. My concerns focus on some aspects of the proposal. For what concerns the automotive sector, the Parliament's resolution does not provide different liability tests in accordance with the level of automation of the vehicle. According to the resolution, a user will always be liable for damages deriving from the circulation of its vehicle, regardless of the automation level. I wonder whether this solution should be considered fair when vehicles will soon be so autonomous to prevent any form of human intervention. This is my conclusion. Thank you very much for your kind attention.
Many thanks, Francesco. It was really interesting. I have a question. I'm not an expert in private law, but my question would be, if we accept the idea that the producer has to be responsible for any problems, or at least the problem is closely related with the functioning of the artificial intelligence, the normal result would be that producers are going to transfer this responsibility, not the responsibility, not the liability, but they are going to transfer the cost, the foreseeable cost of this liability to consumers. Therefore, they are going to increase the price of the car, and that would result, interestingly, in a kind of socialization of this risk. It would be like a way of making everyone to pay for a possible problem or a possible accident of a particular car, which may not be a bad solution. What do you think?
Yeah, I agree with you. I think that consumers could prefer to buy an expensive product, that is, but knowing that the producer is liable, and because I think that the actual proposal provides a liability regime that maybe it's too that aggravates the position of the consumer, and maybe it's maybe I think the consumer could prefer to buy a more expensive product, but knowing that the producer, just only the producer, will be responsible, liable for the damages that could occur by deriving from a malfunctioning of the algorithm of the system. So it's my opinion, but we are still in a phase of proposition, so we have to wait to understand the final proposition of the EU institutions.